They put a gag order on me, and I'm not supposed to be talking about things that bad people do. And so we'll be appealing very quickly. But, you know, people understand it. And normally if you get indicted, if you're a politician, I've watched it for years, they get indicted and they walk to a microphone about 4 minutes later. Ladies and gentlemen, I will be leaving office to fight for my reputation and spend time with my family. I love my family so much. You know, that they're out, they're gone. With me, I have a big platform, so I can explain things.
That was Donald Trump whining about having a gag order imposed on him by Washington, D.C. federal judge Tanya Chutkan in the federal case being prosecuted by special counsel Jack Smith for Donald Trump's attempt to overthrow the 2020 election. I'm Ben Meiselas from the MeidasTouch network. Donald Trump is misrepresenting the nature and scope of the gag order, which simply limits him from threatening the judge, special counsel Jack Smith, and witnesses and all of their families. It says nothing about Donald Trump being prevented from criticizing or even attacking through harsh language his political opposition. It's actually stated in the order itself. Nonetheless, Donald Trump continues to lie, and Donald Trump has filed a notice of appeal stating that he will be appealing the gag order that was imposed on him by federal judge Tanya Chutkan. Here's the notice of appeal right here. It says, Defendant Donald Trump, I'm not referring to him as a president because he's a former president, but he's a criminal defendant in this case. Defendant Donald Trump hereby provides notice that he appeals to the United States Court of Appeals for the District of Columbia Circuit from the opinion and order of the District Court dated October 17th, 2023. The order was handed down by Judge Chutkan in a written order earlier in the day. Donald Trump appealed shortly thereafter. Now, the prospects of Donald Trump succeeding on an appeal like this are very small, and there's not a whole great deal of precedent for an appeal like this. Think about it like this. You have a federal judge in Washington, D.C., who is simply stating that Donald Trump and all parties are prohibited from threatening the judge, this court, our court staff, the special counsel, and the special counsel's team of lawyers and investigators, as well as witnesses, and then all of those parties' families. That's what the Donald Trump is being prohibited from in this gag order, and Donald Trump is appealing that and saying that, no, I want to threaten. No, I should be permitted to attack and threaten. Now, Judge Cannon has narrowly tailored her order, in my opinion, to make it completely appeal-proof. There's nothing here that I think Donald Trump will be able to successfully argue that he has a right as a criminal defendant who has restrictions imposed on him by being under federal indictment that he should be permitted to threaten and attack. I think what this actually tees up, folks, is the D.C. Court of Appeals, I think, actually being far less generous to Donald Trump and Donald Trump's lawyers than Judge Chutkan is. You know, Judge Chutkan, the federal judge, she's a trial judge, right? She recognizes that Donald Trump's trying to do things to cause delay, to try to provoke her, to try to show that somehow she's not capable of being the judge on the case. So she knows that that's his maneuvering here. And so she wants to kind of balance, obviously, making sure she keeps control over her courtroom, which she is doing, but she also wants to keep the trial date, right? And trial is scheduled for March of 2024, and she wants to keep that date and make sure that that date doesn't get moved by Donald Trump's chicanery and Donald Trump trying to bait her. The D.C. Circuit Court of Appeals, they're removed from that. So I think when they look at the record here, and they see threats to the judge, threats of execution, murder to a witness, General Mark Milley, threatening to execute him, attacking former Vice President Pence, attacking special counsel Jack Smith, saying, if you come after me, I'm going to come after you, among numerous other, holding a gun, as he did in South Carolina, when that's a violation of his restrictions. If I'm special counsel Jack Smith's team and Donald Trump's bringing this appeal, I'm like, bring it. Let's have the D.C. Circuit Court of Appeals try to address this, and let's let a court of appeals look at this content. You want to bring it all the way up to the Supreme Court? Do that too. and we will have them look at your conduct here and what you're stating. And I think that Donald Trump will be rejected on an expeditious basis by all of those. I know Donald Trump's trying to use this to delay the trial date. I don't think that's going to happen. I've heard people saying, well, Donald Trump's going to try to seek an order to stay or like delay Judge Chutkin's order. I would be surprised if that is successful in any way. What's the DC Circuit Court of Appeal going to do? They're going to say, we are going to temporarily block an order that prohibits Donald Trump from threatening the special counsel and the special counsel's family, from threatening the judge and the judge's staff. By the way, a gag order like this has also been imposed on him in New York because he threatened the judge's law clerk in New York. I don't see a court of appeals countenancing this and allowing this to cause delay if that's what Donald Trump is trying to accomplish here. The notice of appeal is the precursor to the actual appeal. Donald Trump will have to file a brief. The special counsel's office will respond. I would not be surprised if it gets put on an expedited briefing schedule by nature of the fact that the federal case is set for March of 2024. And again, it seems like it's just another delay tactic of Donald Trump. But if we take a look at the gag order that was imposed, just pull it up right here. This is what Donald Trump is appealing. It states, for the reasons set forth below and during the hearing, in this case, on October 16, 2023, the government's motion to ensure that extrajudicial statements do not prejudice these proceedings is granted in part and denied in part. Under binding Supreme Court precedent, this court must take such steps by rule and regulation that will protect its processes from prejudicial outside interference. The First Amendment does not override that obligation. Freedom of discussion should be given the widest range compatible with the essential requirement of the fair and orderly administration of justice, but it must not be allowed to divert from the trial from the very purpose of a court system to adjudicate controversies, both criminal and civil, in the calmness and solemnity of the courtroom according to legal procedures. And it goes on to cite cases. Here, alternative measures such as careful voir dire, jury sequestration, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address. In order to safeguard the integrity of these proceedings, it is necessary to impose certain restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. Since his indictment, even after the government filed the instant motion, defendant has continued to make similar statements attacking individuals involved in the judicial process, including potential witnesses, prosecutors, and court staff. Defendant has made those statements to national audiences using language communicating not merely that he believes the process to be illegitimate, but also that particular individuals involved in it are liars or thugs or deserve death. The court finds that such statements pose a significant and immediate risk, that witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats, and two, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial as well as trial stages of this case. The defense's position that no limits may be placed on defendant's speech because he is engaged in political campaign is untenable, and the cases it cites do not so hold. It goes on and cites various cases. Accordingly, pursuant to our local rules, it is hereby ordered that all interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target the special counsel prosecuting this case or a staff, defense counsel or their staff, any of this court staff or other supporting personnel, or any reasonably foreseeable witness or the substance of their testimony. This order shall not be construed to prohibit defendant from making statements criticizing the government generally, including the current administration or the Department of Justice, statements asserting that defendant is innocent of the charges against him, or that his prosecution is politically motivated, or statements criticizing the campaign platforms or policies of defendant's current political rivals, such as former Vice President Pence. That's also fine. In addition, the sealed version of the government's motion to ensure extrajudicial statements do not prejudice these proceedings is denied as moot, dated October 17, 2023. That, folks, is the order that Donald Trump is appealing, and I wanted to read it for you because facts matter, evidence matter, the words matter. Donald Trump is lying about what the protective order says. It's very narrow. It involves these threats and personal attacks. Otherwise, he's free to say what he wants. He's filed a notice of appeal. It is going nowhere, in my opinion. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch and have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.